Let's dig into the definition to establish the basic understanding of the true statement. The true statement, equity is equity recognized as equity delights in equity. It means that the equity would put the suing parties on an equal pedestal or level. Equity is equity draws attention to the way of thinking that equity tends towards an equal division of money and property to which people are entitled. Basically, the statement that equity is equity highlights the core belief that fair relief should be dispensed in a manner that fairness among the involved parties. Equity steadily tries to make even the suing parties on the equal plane about their rights. It serves the actualized the fair distribution of the property and losses in the middle of the different claims and things you own presented by the arguing against parties. By supporting as correct to the true statement equity is equity, the legal system aims to make sure that justice is not only served but is also served with a detailed and thoughtful understanding of the fact or condition given to the certain groups of each party involved. As the nature of equity is equity, it embodies the fundamental principle which is applicable to cases where two parties are entitled to an interest in the same property. In the realm of property distribution, this maxim highlights the imperative to ensure an even-handed and just distribution of right and interest among the contending parties. It seeks to prevent any undue advantage or disadvantage to either parties. Second, this maxim is applicable when there is no express provision as to how it should be allocated to each party. This principle is particularly pertinent in cases where the legal framework or contractual agreements lack specific guidance on how entitlements, benefits, or burdens should be distributed among the distributing parties. It becomes a crucial tool to the legal system to address situations where silence and ambiguity in the legal documents might otherwise lead to inequitable outcomes. When a court is faced with significant obstacles or practical difficulties in fairly dividing a property among competing claimants, equity dictates that those who have rightful claim to the distributed equally. This principle becomes important especially when there
In the concept of marital property division, the maxim of equality is equity serves a guiding principle to ensure fairness and justice, especially in distribution of assets and liabilities between spouses during the dissolution of marriage. As we know, the marital property division is a significant aspect of divorce proceedings. Therefore, in this maxim of equality is equity, which emphasizes the idea that unless there are specific agreements or factors that require a different approach, marital property should be divided equitably, ensuring a fair and just distribution. In Malaysia, the Law Reform Marriage and Divorce Act 1976 or LRA and its companion rules, the Divorce and Matrimonial Proceedings Rules 1980, regulate the division of marital property. This area of law concerning non-Muslim is thoroughly examined and clarified. Not to mention, Section 78 of the LRA provides that in deciding the amount of any maintenance to be paid by a man to his former wife, the court shall base its assessment primarily on the means and needs of the parties involved, irrespective of the percentage and such maintenance contributes to the income of the spouse. It directs the court to consider the degree of responsibility attributed to each party for the breakdown of the marriage. In many jurisdictions, the principle of equitable distribution does not necessarily imply an equal 50-50 split of marital assets. Instead, it requires a fair and just division, considering various factors that may influence this distribution. These factors may include the span of the marriage, the competence of each partner to make a living for their respective financial needs and resources, and the distribution each made to the acquisition, preservation, or appreciation of marital property. Furthermore, the maxim of equality is equity, which also may guide the courts in considering the specific circumstances surrounding the marriage, such as whether one spouse has sacrificed the employment opportunities to assist the other's professional growth, or whether there are special needs of the children need to be taken care of. In the case of Mark Sia Angju, the husband was the sole supporter of his family after his wife chose to resign from her job and to be a stay-at-home mother after the birth of their daughter. The court was of opinion that the claim of maintenance is to enable the parties to maintain the continuity of a normal life, but at the same time, the amount of the claim has to be reasonable and will not cause hardship to other party. In another case of Punageswari and Upper Krishnan, the principle followed was the issue of fair and reasonable maintenance must be decided by the references to the facts and circumstances of each particular case. The power to order the maintenance of an ex-wife is a discretionary power that must be exercised in accordance with the general principles. To conclude, these cases not only showcase the court's consideration of equality in property division, but also highlight the importance of evaluating other factors contributing to stability of the marriage prior to its dissolution. The courts, by exercising discretion and considering various elements, aim to ensure not only an equitable distribution of assets but also a fair and reasonable maintenance arrangement, contributing to the overall resolution of complexities involved in divorce proceedings.
Moving on to the next one, which is about the equality in spousal support. It is crucial to note that if there was a dissolution of marriage, not only the husband need to bear the maintenance toward her wife, but it can also be the wife who will be accountable for the maintenance if the husband is ill or injured. Next, the court will also determine who has the financial ability. Then she or he will be the one who to pay for the maintenance to ensure their spouse and children will have an equality opportunity. Other than that, the court will calculate the maintenance based on consideration of both parties while looking into the degree of each party accountability for the dissolution. In the case of Liao Oi Cho versus Johnny Tanujaya Tinjiang, the court dismissed the wife's spousal support claim, reasoning that she was still employed at the time of marriage dissolution and capable of self-support. The judge deemed it unfair for the husband to face spousal support, considering his lost job opportunities due to the criminal charge against him. This decision reflects the court's emphasis on equality is equity. In another case, Sheila Sri Shalini Gomez versus Raymond Schindler anak lelaki Simon, the court considered the husband earning, bank account and asset to determine the spousal support. Reflecting the principle of equity is equality, the court ruled that the husband should pay Rm 1,500 to the wife until she remarries, aligning the amount with the financial circumstances of both parties.
For child custody, one of the most common big problems that follow divorce is the custody battle. Usually, the kid's father and mother each attempt to persuade the court that they should have custody of the child rather than the other. However, it is crucial to underscore that the paramount consideration in such cases is the best interest and welfare of the child, transcending the personal interest of the disputing parties. Child welfare, healthcare, and education is the main consideration that should be emphasized. According to Section 88 of LRA, the court may order to place a child in the custody of either the father or mother or relative or any association, the objects of which include the child welfare or to any suitable person. Crucially, if it comes to light that both parents are deemed unfit to assume custody, the legal framework provides for the appointment of a relative of one of the parents to take on this responsibility. This provision underscores the judiciary's commitment to prioritizing the child welfare and ensuring that custody arrangements are fashioned in a manner that safeguards the child's best interest. For child custody, one of the most common big problems that follow divorce is the custody battle. Usually, the kid's father and mother each attempt to persuade the court that they should have custody of the child rather than the other. However, it is crucial to underscore that the paramount consideration in such cases is the best interest and welfare of the child, transcending the personal interest of the disputing parties. Child welfare, healthcare, and education is the main consideration that should be emphasized.
According to Section 88 of LRA, the court may order to place a child in the custody of either the father or mother or relative or any association, the objects of which include the child welfare or to any suitable person. Crucially, if it comes to light that both parents are deemed unfit to assume custody, the legal framework provides for the appointment of a relative of one of the parents to take on this responsibility. This provision underscores the judiciary's commitment to prioritizing the child welfare and ensuring that custody arrangements are fashioned in a manner that safeguards the child's best interest.
While equality is an important principle, it may not always be the most appropriate approach. Factors are to be taken into account: the child's age, the relationship between each parent, their physical and emotional needs, and the ability of each parent to provide a safe and supportive environment. Okay, next, what problem occurred in Valamati case is that due to the father's indecent behavior, it leads the court to impose restrictions on his access to the child. The court ordered that the father could only supervise access to the child only if he was accompanied by the mother or a person trusted by her, and this supervision was limited to a stipulated time. Additionally, access via telephone was also allowed, but within a specified time frame. The imposition of such conditions suggests that the court had reservations about the father's behavior, potentially deeming it inappropriate or concerning for unsupervised access to the child. The best interest of the child should take precedence over the principle of equality is equity if its decision is unjust to the well-being of the child. In many jurisdictions, family courts prioritize the best interest of the child over the principle of strict equality between the parents. This is because the well-being and welfare of the child are considered of utmost importance of all. In conclusion, when it comes to the concurrent entitlement of two or more individuals to a property interest, equity steps in to treat them as equal entitled in the absence of any specific provisions or agreements governing the situation. The doctrine of equality, however, faces challenges in cases where certain factors demonstrate that a spouse is not qualified for an equal distribution of alimony and the maintenance of life either for themselves or their child. It is essential to recognize that the maxim equality is equity does not operate as an absolute and concrete presumption in the realms of marital property division, spousal support, and also child custody. These three critical areas demand a nuanced evaluation of circumstances, and the court must carefully assess all relevant factors before rendering a decision that is deemed equitable for all parties involved.